And Mr. Cohen's is going to be taking the lead on this motion, and present are my client, Mr. Mallory, Benjamin Mallory, and I believe also on the call are his parents, Peter and Lisa Mallory.
Good afternoon, everyone. When you're ready to proceed, Mr. Cohen, you may.
Thank you, Your Honor. For the record, Dan Collins, present on behalf of Mr. Benjamin Mallory in case number 2019 CF1142. We are present before the court today upon a motion to suppress evidence and any statements that Mr. Mallory made during the confession and interrogation in this matter. The only evidence that we will have to present, Your Honor, will be potentially the exhibit that has been submitted to your office. Did you receive that?
I did not have an opportunity to view it, but I would have received it.
We did intend to publish the relevant portions of that video, and that would be the only evidence that we intend to present. So if you'd like, we can proceed with that.
Right, I'm going to enable the share feature. If you have your video queued, you may play it at this time.
Thank you, Your Honor.
Judge, can I just stay right here? I'm on this case, okay?
You can.
Okay, I'm going to unmute myself, although I'll try not to talk. I don't know if that's going to, muting it or unmuting it's going to make a difference on whether you can hear it or not. But I'm going to go ahead and start, Judge.
So, set up here. Your chair. These things are off in a minute, okay? Just sit tight, right? I'm gonna take one of them off at least.
I'm going to fast forward, Judge, to the part where the invitation occurs.
Yep. All right, man. This is my house, okay? By policy, you got monkeys on your legs. I don't think you're gonna try to run out of here with crazy things. One of those old man. Can I get you something to drink? Let me get you a bottle of water. A little the weather, you like a cold or something? Okay, go ahead, guys. So what we're gonna do is try one out of my answer. And then I'm gonna you let in there right-handed, so right-handed. That's why I say the same cup off the right hand, so you get pretty used to it. Your left hand is here. Is that okay? Okay, good. Stay free, we gotta be relaxed. So while you're here, you can shut your mom off the
Okay, I'm stepping out.
How you today would go with this morning. Dan, I'm an investigator with the Tallahassee Police Department. This is investigator Paul Osborne. He's also an investigator with us. Yes, more. You need his bathroom or anything? I know you just got here, but I'm sure I wanted to bring you up here. Okay. So I want to get some basic information from you because I've been all over the place. You go by Benjamin, the other people. Benjamin. And how do you spell your last name? Mallory, M-A-L-L-O-R-Y. So do you go to Florida State, or you go to any schools here? Or? Yeah, I go to Florida State. Okay. What year are you? Junior. What's done? Yeah. What are you studying? Okay. You're getting a real taste for it today, obviously. Yeah. It's probably not the way that you had anticipated. There you go. Yes, sir. Yeah, trying to make it a little more comfortable. Were you wanting to go into law enforcement, or what were you thinking? Yeah. So how do you like Florida State? I feel all right. Are you from here, or just coming to the school? From Beach. You haven't missed Fernandina, Amelia Island. I think that's one of the coolest places I've ever been to. Like that town area is really just relaxing.
Yeah.
Did you grow up there your whole life?
Yeah.
Next time I see, other than I guess North Florida, what do they call it? They never call it there, but we're probably the second closest to it. I guess that's the closest. Benjamin, have you ever been arrested before? No? Okay. I want to talk to you about some stuff that happened today. I'm getting all kinds of accounts, and your account's very important to me. However, because you are here at the police department, you are under arrest, I have to read you your rights. You may have seen it on TV or different things, but please pay attention. You're under arrest. You are under arrest for shooting at this point, and the charges related to that. But I would certainly like to get your side of what happened with that. But again, I'll give you your rights first. Is that okay? So before you answer any questions or make any statements, you must fully understand your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you for any questioning if you wish. You can decide at any time to exercise these rights and answer any questions or make any statements. That's my name. Investigator Warren. Do you understand each of the rights that I've explained to you? Okay. Have you previously asked any other law enforcement officer to allow you to speak to an attorney about this incident? Okay. And having these rights in mind, are you willing to talk to us about what happened? All right, would you mind signing this? This is just a form denoting your answers that yes, you understood, no, you haven't asked for an attorney, but no, you don't want to speak with us. Okay. All right, I'm going to try to get your paperwork and everything completed to get you to the jail. If you need anything, we'll come and check on you from time to time. If you use the bathroom or anything, with time, just here and relax, right?
What would the charges be?
I have to confer with the state attorney's office, but ultimately discharging a firearm into an occupied dwelling and potential armed burglary. So I have to look into some other things, but again, I have to confer with the state attorney's office on them for final approval. All right.
Whoops. Judge, for the record, that was, where in the world did it go?
No matter, we might have stopped the video or.
Yeah, I did. But when I stopped it, it shut the whole thing off. So hang on 1 second. Let me put it back on. Right. So that was at around, for the record, 12:10, roughly in a few seconds. PM. So now I'm going to fast forward, Judge. I'm just going to move it. And if there's any, the next time you see it will be when the door opens again. I don't think I need to stop at this part.
Hey, then, almost done, man. I'm waiting for your ride to get here. Slightly concerned, just give a couple, some information that explained to me. This isn't about the case. This is separate. I'm here to ask you about the case. This is about you and whether or not you think about harming yourself or anything like that. It's information I have to relay to the jail. And since I got a couple indicators from officers that spoke to people, I just want to ask you a couple questions about that. Like I said, not about the case, but are you thinking about hurting yourself in any way, commit suicide, or have you thought of that recently?
No.
Okay. You think about harming anyone else? No. Okay. So nothing about hurting yourself or anybody along those lines. Am I understanding you correct? Okay. All right. Yeah, I'm asking, so I know we picked you up at the medical facility, and I guess the nurse there has some concerns, and they're going to have some talk to you, so. Because
I'm completely innocent, so
okay. That's fine.
like I didn't do anything. So
So, like I said, I can't, yeah, you're right, Stu, both of them, that's perfectly fine. I'm not trying to talk to you about that. I'm just asking you about these other things. Does that make sense?
Judge Everett, I'll continue to fast forward. I'm not going to try to stop it again and lose the video like I did last time. But we'll note that when the door closed there on the video, actually,
I can't,
that was time marker, looks like 13:16,
perfectly fine. I'm not trying to.
roughly an hour after we stopped it the first time. All right. And I'll begin playing again at 13:26:50.
Yeah. Again, like I said, we're trying to squeeze that thing through. You don't have a choice, man. So they just stood up and turn off. We're almost done. That's why these guys are back here. So, it'd be much longer. You have any anxiety issue, something with anxiety, or something you know about? You take any medication?
a lot of stuff like
Are you taking it actively? And are you taking meds?
neither.
Any type of drug use? You know now you come down from anything, withdrawal,
Maybe tobacco.
else? Pot, cocaine, meth, anything?
Like this dude was really stalking me, like long term, and I didn't know what to do.
Yeah, well, that's disturbing.
Yeah, so
I heard you invoked your rights and didn't want to speak about it. And like we were talking. You good? Okay. So who's talking? What's going on?
he's like a real stalker.
Really?
It's like preying on me,
Okay. Tell me about that.
and like I didn't know what else to do. He's my waiter, and then he moved in right next to me.
Okay.
And it's just too weird, like the way he just like is into me. So
Yeah.
it's like
Sounds really weird. Waiter, where?
or he was a waiter when he first signed in.
Where at? Okay. You remember which one?
Those competitors.
Okay. Been there. So what's the stalker's name?
Raphael, that's the competitor.
Okay. What makes you think that this was happening to you?
I just feel all the time, practically there. Yeah, I told people, and I told the LC a lot, and no one did anything. So,
Okay. I talked to the staff and I saw that you had sent them a message a couple days ago, right, about that. Did there any follow-up on that? Okay. You should think about maybe calling the police department. Well, that's certainly upsetting. That he's saying things.
So,
I'll go over and tell us.
absolute pause it here.
Yeah, I was just doing that, Your Honor.
Audio playback is a little hot on my end. I got most of it, but I am going to have to rewatch the video copy that you sent me.
I understand, Your Honor. Actually, I was about ready to stop it anyway, because at this stage in the game, we're actually talking about the statements that should be suppressed. So actually, I don't know that hearing them per se is, for the purposes of our argument today, is important. But yes, if you'll listen to them later, that'd be great. Mr. Combs, do I need to do anything else on this end?
No, that's fine. And Your Honor, for the record, I have had conversations with Ms. James about this issue, and we have actually agreed that the majority of that is actually not going to be admissible and should be suppressed. There's really only one small portion of that video that we are in dispute about, and that will be the focus of the motion today. Before I proceed, just for procedural purposes, I'd like to admit that into evidence, Exhibit 1, which has been submitted to the court.
Right,
That's Exhibit A, when I apologize.
the recording of the interrogation will be admitted unless there is objections, James.
No, sir.
So I have to move on to argument.
Did the screen share stop?
It does.
Okay.
I'm sorry, I didn't hear if you were told me to proceed, Your Honor, but I can.
We can proceed. Go ahead.
Thank you. So, as Your Honor will note, Mr. Mallory clearly invokes his rights at the very onset of the interrogation. The officers honor that and vacate the room and leave him to his own devices for approximately an hour and a half. At that point, due to what can only be described as a perceived misunderstanding as to his ability to leave, Mr. Mallory gets up and tells the officers that he would like to leave. They inform him he's not able to leave, and they come and re-secure him to the chair. At that point, Officer Grasso initiates conversation with Mr. Mallory, asking various questions, first relating to his health, anxiety, mental health, whether or not he has any prescriptions that he should be taking and if he's taking them. But notably, he then proceeds to ask him about his drug use, but specifically any prior drug use, any drugs that he may be coming down from or are in withdrawal from, anything along those lines. And so our position is that this was a reinitiation by law enforcement after he had clearly invoked his rights, and anything after he had invoked his rights should be suppressed from evidence. As far as the potential for it to be incriminating, the standard as far as what is interrogation is whether or not it is reasonably likely to elicit an incriminating response. We would posit that that absolutely is the case here, specifically because they are asking Mr. Mallory about his prior drug use. And if the court will note, this is only a few hours after the alleged incident occurred. So they are asking if he's coming down from anything. Have you taken any drugs, any meth, pot, cocaine? It's clear that Mr. Mallory inferred them to be asking about what had happened earlier in the day, and whether or not he was coming down from drugs that were taken previously at the time of the incident. And that is evidenced by Mr. Mallory's response about this gentleman allegedly stalking him. And so these officers initiated what we would posit is absolutely considered interrogation. They initiated contact with him after he had clearly invoked his rights. And as laid out in the motion, pursuant to the Florida Supreme Court in Shelley State, they have clearly established a precedent that after a defendant has invoked their rights, before any additional interrogation can proceed, they must be specifically advised of their rights again after an alleged reinitiation. So our first claim is that this is absolutely not a reinitiation by Mr. Mallory, but rather by law enforcement. Mr. Mallory is not attempting to have any contact with law enforcement other than to advise them that he would like to leave. And so when the officers begin to question him, that is at the direction of law enforcement. That was not a reinitiation by Mr. Mallory. However, if it is perceived to be a reinitiation, again, that does not rectify the procedural issue here. There was absolutely not a specific re-advisement of Mr. Mallory's Miranda rights as required by the Florida Supreme Court. Officer Grasso apparently attempts to meet this standard by reminding Mr. Mallory that he's previously invoked his rights, but the colloquial term that he uses, you good, that's absolutely not sufficient to meet the standard as laid out by the Florida Supreme Court. And so we would present to the court and posit that any statements that Mr. Mallory made after that point and after he invoked his rights should be suppressed from evidence. And that includes his comments about this gentleman stalking him upon Officer Grasso's prompting by asking about his prior drug use.
Right. I'm gonna ask one question and I'll allow Ms. James to give her a brief rebuttal. As a part of the booking process, does the sheriff or do the police have an ability to ask questions essentially that deal with safety, such as if someone's exhibiting mental health issues, like what's your prescriptions? Do we need to get you something? If they start talking from there, your argument would otherwise be the same, or is it any different?
I think my response to that would be twofold. First off, if you would notice in the video previously, when Investigator Warren comes in and begins to ask Mr. Mallory questions, he specifically says, just so you know, this is not related to the case. This has nothing to do with the case. I'm just asking you questions for other purposes, and I just need to ask you some things to make sure you're doing okay. And he asked him about his mental health, whether or not he's considering harming himself or others. If that was the intent, then that is the appropriate way to handle that situation. Officer Grasso clearly doesn't do anything of the sort. He comes in and just begins to ask Mr. Mallory questions. And I would also posit that any question that he asked Mr. Mallory at that stage could be reasonably likely to elicit an incriminating response, a response that they would intend to use against Mr. Mallory. So do they have the ability to ask certain questions to check on his health? I mean, I would say sure, they absolutely have the ability to do that, but not with the understanding that those responses then become admissible as evidence against him. They can use that to check on his mental health, to check on his health in general, but not then use those against him in his case. No given response.
Are y'all able to hear me on Zoom okay?
Yes.
So again, like Cannon or Mr. Cohen stated, I am in agreement that everything after when the officer says like, oh, you said you didn't want to talk to us, are you good? Everything after that, I'm in agreement that that is suppressible. So I don't really need to argue on that. This defendant, he doesn't just like get up and walk to the door. He squeezes out of his handcuff, and the behavior that he's exhibiting while he's sitting in that interview room by himself, he's very fidgety. He's like rocking back and forth. So I would argue to the court that the officer asking him, like, are you coming down from something? Do you have anxiety or something like that? It's based on his behavior. It's not because of anything with the case. It's based on the fact that he just squeezed out of a handcuff and appears to be very just like antsy. His response when he says like, no, just tobacco, and the officer says like, are you sure? Like, is there nothing else? The defendant sort of randomly says, well, this dude was stalking me and I didn't know what to do. So it wasn't really in response to any question, really had nothing to do with anything. He just sort of blurted it out. And I think when Your Honor watches it back, you'll see that it's random. How he just says it has nothing to do with what the officer said, or was asking about. So I think that, I guess that one statement, that sentence he states, I think that's spontaneous. It comes in, but everything after that I agree does not come in.
Right. Any authority other or just spontaneous statement of the position of the state as to that one line?
Yes, sir. I'm just arguing it's spontaneous. It wasn't in response to anything the officer said or asked.
All right. I will take under advisement. I will listen to the audio and watch the video again, and I can hear everything completely clearly.
May I respond very briefly, Your Honor?
Go ahead.
I just wanted to note that regardless of what Officer Grasso's intent may have been, that is also not the standard. The standard is an objective, reasonable standard. Whether or not this question could have been reasonably likely to elicit an incriminating response. So regardless of Officer Grasso's intent, that is not the standard. I just want to make sure I brought this to the board's attention.
For all statements that follow Officer Grasso's line, yeah, I know you invoked your rights, didn't want to speak about anything, but we're talking, you're good. After that, I will suppress those statements. The one statement that still requires a ruling is under advisement, and I'm reserving at this time.
Understood. Thank you, Your Honor. That's all.
Judge, we already have dates set, and we are actively trying to work this out. We've had a lot of conversations about it, Your Honor, but If something happens, we'll let you know, and thank you.
Have a good day.
Thank you, Your Honor. Have a good day.
Next case, State versus Walter Rayborn, 2015 CF 2120. Ms. Lobby, good afternoon.
Good afternoon, Your Honor. How are you?
I'm doing well. Ms. Kappelman.
Good afternoon, Judge.
I believe we're here on the defense's motion to compel unless we had something else that was teed up.
Judge, it was a motion to compel, but it was also a status conference, a special status rather than appearing tomorrow.
That's fine. Well, and then we can get into the status.
So Judge, let me tell you the actual status of the motion to compel. So when I filed this motion to compel, and the court can see from the body of the motion why it ended up being filed, I then heard on Wednesday from the investigator who was in this case previously. I heard from him on Wednesday and on Friday, and he forwarded me what he had done on the case. And what he had done on the case was rediscovery. So, and there are some visits with Mr. Rayborn that he recounted. But other than that, there was nothing from a defense perspective that appears was done on the case. And so, and then I did learn from what I got from him that there was at least one and possibly two other now investigators. I mean, there was definitely one other investigator on the case prior to him, possibly two. So now I have to explore those. I didn't know that until actually Friday when he got back to me on something else. So he has told me, Judge, I did subpoena him for the hearing, but he told me that he has given me everything that he has, and I can tell the court from the time I asked for a copy of his timesheet because I wanted to be sure, and I can tell you from my review of the timesheet, it appears that there were visits and there was review of discovery on the case.
Investigators on, I guess, Mr. Prince's staff or just professionals hired by him?
I believe it was professional hired by him, and then there's definitely one other investigator who may have been hired by counsel prior to Mr. Prince. And then there's another name that I came across that appears to be an investigator, but I'm unclear as to whether that investigator works with the same firm as the one who was hired prior to Mr. Prince's investigator or not. And because I didn't know this information until Friday, so I haven't had a chance to explore that. My plan is to reach out to Mr. Prince to find out.
Right. So the defense then is withdrawing its motion to compel then as to Carl Knight.
Yes, he indicated, Judge, to me that he provided me what he had. So, and that was on Wednesday and on Friday of last week.
We can repeat that again for the court reporter. She wanted to start again with the indicated.
He indicated that he had provided me with everything he had, and that was on Wednesday and Friday of last week.
Right, let's move into the general status of the case now.
So, Judge, the reason that I wanted this set for the special status is because we've had two statuses, one in June and one in July, I think. And obviously the court, wants the case to move, and I understand obviously the case has a lot of age on it. But I felt it necessary for me to convey to the court I didn't want other lawyers to have to sit and wait and listen to me tell the court what I needed to tell the court. Last time we were in court, you indicated that you would like to have some depositions set prior to the next status, which I thought was going to be difficult to do given the amount of material that I needed to review and so forth, and things that I needed to do. I I can tell the court that we have scheduled some depositions for August 16th and August 30th. There are about 15 depots set currently, but Judge, based on information that I have, there are at least 50 to 56 witnesses that need to be contacted by the defense, and these are not witnesses that are listed by the state. And there are up to 46 sets of records that were never requested in this case. Now, 6 of those 46, some were gotten, but they are obviously incomplete. So I say 46, but 6 of those, there's some records from these entities. And I can tell the court based on my prior experience that once we get these records, there's going to be a lot more than 50 to 50 witnesses to contact and investigate in this case. I mean, I'm sure the court's aware that, you know, the ABA standards that govern the representation of capital clients, you know, in matters such as this. And I would just, I don't want to belabor the point, Judge, but I would just point the court out to Rompilla versus Beard, which is at 545 U.S. 374. It's a U.S. Supreme Court case from 2005. And so in that case, Judge, there were maybe 6 interviews that the attorneys had done with some family members and so forth, and there were 3 mental health experts that the attorneys thought did not really provide any fruitful information to them. And in that case, there were not school records that were examined, despite counsel's knowledge of the education of the accused in that case. The records from his juvenile and adult incarcerations were not looked at, although the lawyers were aware of the client's criminal history. And the court said, while counsel knew from police reports provided in pretrial discovery that Rompilla had been drinking heavily at the time of his offense, and although one of the mental health experts reported that Rompilla's troubles with alcohol merited further investigation, counsel did not look for evidence of a history of dependence on alcohol that might have extenuating significance. I bring that up, Judge, because we have a case here where the state knows this. It's undisputed that several different witnesses are commenting on the use of, on Mr. Rayborn's use of Xanax, and extremely heavy use of Xanax. And so I bring that up because here we have a situation where we don't have school records, we don't have juvenile and adult incarceration information. There is this issue with the Xanax going on, and
my next question to you is going to be, if you had to put these records in categories, what exactly are we talking about? Also, do these apply more to the mitigation track of this, or going through the guilt phase?
No, they apply to the mitigation. My understanding from prior counsel is there was discussion pre-COVID where the case was ready for trial, but was never actually set for trial. And I know everybody does things differently, Judge, but I'm just quite frankly dumbfounded as to how the case was even ready to go.
I think so. We can clear this up. In the spring of 2020, this was on the trial docket and then continued. That was by the predecessor judge to me. But ultimately, when I say that I want this to get to trial, this is also with respect to Mr. Rayborn as well. Rayborn has been in the county jail going on now almost 6 years. Thank you for the correction, sir. I don't think he really wants to pay the sheriff rent, so eventually I think he wants some resolution one way or another.
Yeah, Judge, we've had, Mr. Rayborn and I have had phone conversation. I can tell the court I've tried to set up the Securus video visits with him since they got it, which that would be on 2 occasions I've tried to do that. But his cells got moved, and so it was scheduled with the prior, whatever cubicle he would go into for that particular place he was housed. And then they moved him in the interim. And when I called in for the Securus visit, they wouldn't move him next door to the one that I had scheduled it in because they had moved his house. So we've had phone contact. I do have, I say tentatively because I don't know what's going to happen with the COVID situation. I do have an appointment. They let me set up a special appointment to see him in September. So the plan is still in place to do that. And we've had, I mean, I'm not going to lie, we've had good conversation on the phone, Your Honor, we have. And I've made him aware of all these things. And I understand the court's position. I will also note, and I may have mentioned this before, but prior counsel, for perhaps strategic reasons, I'm not sure, did not take any depositions in this case. Now, co-defendant's counsel took 4 depositions, I believe. And I think I've reviewed 3 of those for her. But there weren't any taken in this case. And I'm talking even strictly just guilt-based witnesses. So it puts me in a little bit of I want to be able to explain to the court that perhaps I handle it differently than the prior lawyers, but it's really, there's a, I think, and I would have given the court a copy of the case had I been there today, but Judge, I don't know if the court is familiar with Rompilla, but it talks about when, the counsel has reason to think that there's other things that are out there, they can't just sit by. And I know the court knows this, but I just feel it necessary for record purposes to go ahead and have this status and let the court know that, the way that we prepare our things, the reason I'm able to tell you right now 50 to 56 witnesses and then 46 sets of documents is because I spreadsheet all that along with the mitigation specialist. And that's why I'm able to give you those actual numbers. And I'm positive that once we acquire other records, that number will go up.
But in terms of obtaining these 46 documents, do you need orders from the court, or what is the issue to help move this along?
Some of them, Judge, I don't think we're going to need orders from the court. There may be, just look here. There may be a handful that we will need orders from the court for, and I'll take a look at. And what I'll try to do with those, if I can, is just schedule that so it's all in one motion rather than separated. We decide to do it that way.
3 weeks, if you can go ahead and get filed the motions that need some order to obtain those records, so that way that can move along. Now, you said, as it relates to the mitigation documents, you were seeking school records, medical records, what other matters? And you can just give generalized categories.
Judge, all of these are background. I mean, all of this is background information. I'd really, quite frankly, rather not say it because the prosecutor really doesn't have a right to know until I review what I get. I mean, I would say some of these are things that the court or the prosecutor would expect that a lawyer would seek when having to put on a phase 2 of a death penalty case. Some of them are particular to this to this individual that other individuals who are facing the death penalty may not exist in their background.
Right? So bottom line then, Ms. Ravi, in terms of actually getting to the finish line, do you believe this is going to be possible by the summer of 2022?
I would say maybe more the fall, and the reason that I say that, Judge, is because I'm set for a death penalty trial beginning September 20th, and then one beginning the last week of January, and another beginning the beginning of June.
All right. Do you have anything else you wish to bring up as status?
I don't, Your Honor. I would just ask maybe an October status, since I have the September death penalty case currently set.
Ms. Koppelman, do you have anything for today?
Just to mention that I do have some of the records that were mentioned, and they should have already been provided, but I'm happy to provide them again. I have the DJJ records and the DOC records, and I believe school records as well. So I can coordinate with defense counsel if those are some of the things that are still needed.
Judge, those are some of the things that are incomplete. So, and we usually do our own records requests. So I'm hoping that once we do that, we'll get it complete. And then what we do is we follow up with updates generally. So.
What has everything turned over from Mr. Prince's office that was not confidential work product?
I'm sorry, say that again?
I said, has everything been turned over from Mr. Prince's office that was not confidential work product?
To my knowledge.
All right, just wanted to make sure there was compliance with the court's order of your appointment in that regard, because if there are any outstanding documents or records that would otherwise be, you would be holding on to, I don't want this to be a holdup as far as progressing forward.
I mean, he's indicated he's everything, Judge, and I think his paralegal delivered maybe 6 boxes of things that were not scanned. And so I have those.
But if possible, if any of your missing documents are in those boxes, maybe that might solve the issue as well.
Well, yes, that's true, yes. Although,
not looking for you to speak, sir, but you know how to get a hold of your attorney. We are going to continue progressing forward, so eventually we can get this to resolution, right?
Yes, sir. And so you know, Judge Everett, I understand this has been going on for a while, and trust me, I'd like to get it over with, but I would much rather let Miss Halliday and her team have as much time as needed, so it can be done the proper way.
Well, that's why you have counsel. She's looking out for your interest.
Yes, sir. I appreciate it.
Judge, I just wanted to bring something else to the court's attention that was brought to my attention this afternoon. And I guess, obviously, I need to look into it some more. There's apparently somebody who, I don't know, maybe some attorney or somebody who is
Live streaming.
these court proceedings. Is that correct?
I believe Mr. Wazowski, is that who you're referring to?
I don't know who it is, Judge.
Correct.
Interrogation, that would be the showing up here.
Okay. I mean, I might address that at some point, given the nature of this case and pretrial publicity, but I'll have to look into that.
As this relates to an open courtroom that's guaranteed by the Constitution, if we need to close the courtroom, please file the appropriate motion ahead of time. But
Yes, sir.
he is a member of the public who can appear and otherwise watch the proceedings. So to that end, not limit his constitutional rights, so everyone understands that's clear.
Yes, sir.
Right, do we have anything else for this afternoon other than setting the date?
I don't believe so, Judge. Thank you.
Right, what are the October dates for case management?
Tuesday, week 12.
Right, October 12th at 2:30 in the afternoon, we'll have the next status conference.
Yes, sir.
Judge, I'll be in another trial that week. Is there a later date in October available?
What are the November dates?
November, the Monday is the majority.
November 9th.
Yes, sir.
It's allowed in 3 weeks if you can file the motions that will otherwise, you need orders for to progress some of these categories of records that are outstanding. Please do so in the next 3 weeks. Any orders that I'm able to sign, I will go ahead and do that so we can keep this moving.
Yes, sir. And that's 2:30 on November 9th?
2:30 on November 9th. That's all right, the private docket.
Yes, sir. I appreciate your time. Thank you.
Have a good day.
All right, you too.
All right, Mr. Rayborn, you're all done, sir. Have a good day.
I appreciate it. Thomas Dale.
Right.
Okay.
Leave, unless there has been an agreement reached, there's a dispute as to whether there was negotiated plea.
Yes, Your Honor, I could.
And I wonder, Ms. James is about to join us. And Mr. Crosby is on screen from the jail. Ms. James?
Sorry, Judge, we're starting at 4, right? Am I late?
No, we're getting started. Mr. Chair is in the courtroom and Mr. Crosby is on video.
Okay.
Case number 2019 CF 440. Go ahead, Mr. Chair. Yeah, approach, Your Honor. You may.
I have had COVID, both of her shots, you know what I mean, sir?
All right, have the parties reached an agreement regarding the admission on the VOP?
Sir, Judge, I don't know. Okay, so I was a little bit confused at why this was even back on the docket. There's no plea agreement in this case. Mr. Cherry and I think if Your Honor remembers, they were gonna file a motion to dismiss. I've only been the prosecutor that's ever worked on this case. I'm the only one who's ever communicated with about this case. And we talked about it this afternoon, and I thought it was pretty clear. For whatever reason, last week, despite the fact that I'm the only one that's ever talked to him about this case via email and court and on Zoom, he reached out to, or someone from his office reached out to, I guess, my office or one of the misdemeanor prosecutors, who is McLean Edwards. He's a misdemeanor prosecutor. This is a felony case. It pled down to a misdemeanor, but it is a felony, which is why I have been the only one working on it. He was the misdemeanor prosecutor was reached out to and was asked, oh, well, what do you want in this case? What's your plea offer? So the misdemeanor prosecutor, not knowing that I had been the one exclusively handling this case because it is a felony, made a plea offer. As soon as I found out about that, I immediately was like, wait, hold on, what? I'm the only person that's ever been working on this case. Why would there ever be an offer with a totally different prosecutor? I called Mr. Cherry about it this afternoon and let him know that there is no plea offer in this case, and that certainly is not the plea offer. And also, I'm the only prosecutor that you ever even talked to about this case. So I don't really know how what I said earlier was unclear, but there is no agreement in this case. I did tell him I would review it and look it over and let him know what my plea offer was. I told him it would not be a weekend in jail, which apparently is what he worked out with the misdemeanor prosecutor, but that I would get back to him as soon as I could with an actual offer. But it certainly is not going to be a weekend in jail. So,
Mr. Chair, unless this is an admission, I'll allow you to place on the record what you'd like to place on the record, but it doesn't sound like we have any plea happening today.
Yes, Your Honor, the email I sent before you lays it out. Your Honor, we originally came, this was a overcharged felony for a DUI bodily injury. They didn't have the evidence for bodily injury, got pled down to a misdemeanor and felony for it. We had an issue when he had an alcohol violation. My toxicologist looked through it. Clearly there were some problems with it. We were filing a motion to dismiss on that. I think we would have been successful, but he violated again. Mr. Crosby, the chances of this happening and having two mistakes, Your Honor, I think it's pretty remote. And I told Mr. Crosby that we needed to work something out with the prosecution. I called the state attorney's office and said, who is handling this case? Because prosecutors change so regularly. When I was there, we almost every month, it seemed like they were running through somebody different. They sent me to Mr. Edwards. Mr. Edwards looked at the case and he confirmed he was handling it and that he gave me an offer of 3 days, which a weekend in jail, to take care of this. So I said, okay, I'll draft up the paperwork. I drafted up the paperwork. He signed it, my client signed it, I signed it. He turned himself in and he has spent those 3 days in jail now. And I'm the prosecutor on it, I'm supposed to handle it. Well, that's an internal issue for the state attorney's office. And I understand the case law, Your Honor. The case law is they don't allow it to be enforceable until the point that the judge signs off on it. But from a fairness perspective and an ethical perspective, they honor what this guy agreed to, because this is why my client turned himself in. This is what his family depended on when I consulted with him about it. What I'm prepared to do today, Your Honor, is to plead him straight up and have you look at it and see if we can't just resolve this, because he was as either 14 or 15 days away from being final. He's done everything he's supposed to do, but he's violated the alcohol conditions twice. And he's prepared to admit to that and throw himself in the mercy of your court. What I would submit is fair in that situation is the weekend he's already served that he bargained for, that he's done. And that's where we're at, Your Honor.
Right. Mr. Crosby, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can lower your hand. Please state your full name and give your date of birth.
Vlad Alex Crosby, 07-16-98, July 16.
Mr. Crosby, do you understand the difference between a negotiated outcome and giving what's called an admission or a plea to the court?
No, sir.
Right. Do you wish to give an admission to the court and your attorney can explain to you what that means? Mr. Cherry, you can explain to Mr. Crosby?
Yes, Mr. Crosby, what this is, we're pleading directly to the court, meaning you're admitting your violations, that you had an alcohol violation twice, and that the judge can do whatever it is the maximum is. He can send you to what we've agreed to, all the way up to a year in jail. And that's if you admit to this, that's what his options are. He is not restricted by anything, and it's what he thinks is fair is what's going to happen.
Right, Mr. Crosby, and understand, well, first of all, do you understand now that your attorney explained that to you?
Yes, sir.
Do you wish to have your attorney seek a negotiated outcome, or do you wish to give an admission or open plea to the court?
Would he tell me, like advise me?
Yes, my recommendation is you plead directly to the court, Mr. Crosby.
Okay. Then yes, sir.
Right. Mr. Crosby, are you admitting at this time to the first numbered violation, which otherwise has allegations of you having 2 positive alcohol tests?
Yes, sir.
You understand with your open admission today, there's not a negotiated outcome with the state.
Yes, sir.
You understand that you can be sentenced for anything from credit for time served to the lawful maximum, which would be a year in the county jail.
Yes, sir.
Are you under the influence of any alcohol, medication, or drugs today?
No, sir.
Are you thinking clearly?
What? I'm sorry?
Are you thinking clearly?
Yes, sir.
Do you understand the decision that you're making in giving an open admission?
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
Has anyone threatened or coerced you about making this decision?
No, sir.
Has anyone made any promises or inducements to get you to make this decision?
No, sir.
Do you believe that giving an open admission is in your best interest?
Yes, sir.
Have you had enough of an opportunity to speak with your attorney, Mr. Cherry, concerning the facts of your case?
Yes.
Did Mr. Cherry answer all of your questions?
Yes, sir.
Is there anything else that you wish to discuss with Mr. Cherry today before your case is resolved?
No, sir.
Did Mr. Cherry advise you as to all of your possible outcomes?
Yes, sir.
Is there anything that you wish to ask the court concerning what it means to give an open admission or anything else?
No, sir.
Then based on your testimony, I will accept your open admission today of the fine that's been given freely and voluntarily, that you understand your legal rights, and also the law and ranges that you face. Mr. Cherry, you can present your argument for sentencing and any mitigation that you have about his performance on probation.
Yes, Your Honor. Mr. Crosby has completed his conditions, special conditions, and complete and payments. The only thing that was left was to finish, I think by the second one, it was either 14 or 15 days left and it would have been terminated. Mr. Crosby has had some difficulties. I think the alcohol is a symptom of this. He grew up in a tough place in the Ukraine where he was neglected, sent to an orphanage, and abused at the orphanage, where a very nice family here in town adopted him. And he's lived pretty much without problem until recently. He had a underage alcohol charge, then this came up where he was DUI. It was overcharged at a DUI, serious bodily injury. It was not serious bodily injury, and it was pled down as such to a first degree misdemeanor. But considering he has completed all his special conditions, he does have these two violations, and the fact that, he accepted responsibility for this and he thought he had a negotiated plea. He spent this past weekend in jail, which is not something that he ever intended to do. And he's here today at the finish of what he thought was agreed. I would ask the courts to sentence him to time served and terminate his probation.
James?
Judge, so I would ask that Your Honor take judicial note of the court record before I start my argument, which I'm sure you already have, but I would ask formally that you take judicial notice of it.
I take judicial notice of the court file for the case. Go ahead.
This defendant clearly has a drinking and driving problem. And the largest issue I see is that every single time he's been tested, his blood alcohol content initially on the underlying offense was 0.225, which clearly is very concerning. He was driving in a way that somebody had to go to the hospital. There was two drivers, one had a broken arm and one suffered a head injury and had to go to the hospital. And then he was put on probation. And in February, he tested and it was positive for alcohol, so he was still drinking. And then again in July, he tested and it was again positive for alcohol. So whatever conditions he did, clearly they didn't do anything because he's still drinking. And I imagine somehow he's getting to these probation appointments. Maybe he's not driving, but I guess we don't know that. But I would assume that he's driving to get there. Regardless, though, clearly the point was not made by whatever conditions he had to do. Drinking and driving is very serious, especially because he already injured two people and clearly continues to drink. I would ask Your Honor to sentence him to 1129 in this case, which was going to be my offer anyways. And I would submit to Your Honor, and again, this is just my argument, the defense in this case knew very well that I was the prosecutor in this case. They went to the misdemeanor prosecutor because they did not want to hear what I had to say about it in terms of my plea offer. I'm the only prosecutor they've ever communicated with on this case. So I would ask for 1129 based on this defendant's actions and his complete disregard for what this court has ordered him not to do, and for the disregard of the community and the fact that he continues to drink.
Right, as far as the conditions that have been completed positively, are there anything, or is the state showing any other outstanding conditions other than just what we have as far as the allegations of the tests?
No, sir. Outside of the positive alcohol testing, no.
Right? Right, Mr. Chair, want this opportunity to argue if you wish.
Yes.
Sir.
The prosecution argues that she wants you to assume that he was driving to his appointments. His mother took him to his appointments, Your Honor. There's no evidence that he was violating his conditions of not driving. That's just not true. He did have 2 alcohol violations, which he has admitted to after doing almost the complete probation, short 14 or 15 days. And as all the payments, all the educational programs, everything else. And as far as him having a problem, Your Honor, we don't dispute that he has a problem, but he's gone through the issues, the programs that were provided by the state, and as soon as what we intended to do is to get him in this weekend of jail and to get him into counseling. He's got problems from his time in the Ukraine and the things that he went through with abuse, but that's not going to be solved by the court. His mother is certainly getting him into programs. He has been sentenced and has done 98% of what he was supposed to do. It's the alcohol issues that he's had 2 of those that he's admitted to. And he spent 3 days in jail because of that. And I would ask, Your Honor, that he is time served and that's completed so that he can get on with his counseling.
Right, Mr. Crosby, in light of the positive performance, I want to take that into account as far as determining what your sentence is today. But essentially, with a DUI probation, one of the primary features is for you to either stop drinking, whether it's based on the counseling or the treatment that you receive, or even if it's the threat of incarceration, but ultimately you can't drink when you're on a DUI probation. Here we are faced with 2 positive tests. So on that basis, I am going to sentence you 30 days. You will receive credit time served for all the time you already have spent in custody. How much time is that, Madam Clerk?
3 days, it's not addressed.
Right, 27 days of total jail time, 30 days credit time served for that. From here, sir, when you get out, probation is revoked and terminated. I want you to understand, just because probation is over, that doesn't mean that the things that will be helpful to your future as far as getting away from alcohol abuse are going to get any easier, but you're still going to have to put in the work, even without the threat of probation hanging over your head, to have a positive life and also to be free of being in the court system. I hope this makes sense to you. Jail, you are going to move the fingerprint Mr. Crosby and send those to the courthouse. That terminates the probation. You're all done, sir. Oh, yes, $50 cost of prosecution. I don't believe the public defender was ever appointed in this matter, Mr. Chair.
I took this over from Mr. Casey, the favor, so I don't know, Your Honor. He went to law enforcement and I helped him with it.
Right, $50 cost of prosecution, probation terminated, sentence 30 days, credit for time served, does apply. Have a good day, sir.
Thank you, Your Honor.
All right, let's move on to our 4:15 Taylor Barden. When it was another 4 o'clock. It's case number 2021-1799. Ms. Fernandez.
Yes, Your Honor, thank you. And I believe Ms. Bingham is present. Judge, I also see Ms. Tracy Kennard present, that's the alleged victim in this case. Your Honor, Ms. Kennard filed a pro se motion asking for peaceful contact in this case. I submitted that to the court and adopted her motion. I've also confirmed with her that she is seeking peaceful contact. In addition to that, I'm sorry?
So when was it filed?
I received it from the clerk's office, and I also sent it over when I filed my motion to Ms. Underwood.
Go ahead.
And so, Judge, based on her wanting peaceful contact as well as Mr. Bernard, as well as Mr. Barden, we adopted her motion and asked for the court to grant peaceful contact. And in addition to that, the motion that Mr. Victor Holdred previously filed on this case was for removing the GPS. So what we're asking today is Mr. Barden and Ms. Kennard both want peaceful contact. They've recently had a child together, and we're asking for them to be able to have, and I've explained this to both of them, peaceful contact with each other. And then if that's granted, there will also be no need for the GPS. The GPS is a substantial hardship for Mr. Barden right now. He does work substantial hours. The length of period that he needs to be charged, plus the cost that the GPS is costing him, is adding up, and that's a hardship for both Ms. Tracy Kennard and Mr. Barden. And we rely mostly on our motions.
What is the state's position?
Judge, I have no position as to the GPS. Can you hear me all right, Judge?
Yeah.
Okay, just wanted to make sure before I continue. So I have no position as to the GPS. As far as the peaceful contact, I would object. As always, I understand the situation. I understand how it is when a child is involved. However, based on the nature of the case and the facts contained in the probable cause affidavit, I would object to peaceful contact at this point.
All right, with regard to the peaceful contact, I see where the realm of pretrial release filed an email, but I don't actually see the pro se request.
Is Your Honor talking about Ms. Kennard's motion?
Yes.
And Judge, what I can do is I can e-file it. I also,
For right now, if you bring it up on your screen, you can share it and I can take a look at it.
yes, Your Honor. Judge, and I'm sorry.
I also have it pulled up, Judge. I don't know if you'd like me to.
Whoever's capable of sharing it first.
You have it. I've just found it. Thank you.
Can you see that, Judge?
Yes.
And I'd also point out that Ms. Kennard is present and let her know Your Honor might have some questions for her.
Right, I have finished it.
Okay.
And Judge, if I may add,
Yeah.
I also, I've received information from, and I believe this was e-filed with the clerk, so it should be in his record, that he is attending Appalachia an out-treatment program. He is in compliance with that. He's going to all of his case managements with Appalachia. Miss Jasmine Queen went ahead and tied me into that so I could see his reports. He is doing everything that he needs to in order to get himself in the right position, and I believe that he is in a good spot right now in comparison to when this case was initiated.
All right, Ms. Kennard, please turn on your video, your audio. Please raise your right hand, Ms. Kennard. I'm going to swear you in. You swear or affirm that the testimony you're about to give will be the truth.
Yes, sir.
In the part, lower hand. Kennard,
Sir?
you've been apart from Mr. Barden for a few weeks now,
Yes, sir.
and you no longer fear him or fear for your safety.
No, sir, I do not.
What do you think is going to be different if you were to have contact with him?
Since he's doing everything that he's supposed to, I feel like, everything's gonna go perfectly smooth as long as he continues on with the stuff that he's supposed to be doing.
Are you in need regarding your child care, or is this something else?
No, sir, it's just, I would really like him around.
Do the attorneys have any additional examination?
Mayor.
No, sir.
I'm just going to take a moment to read the arrest affidavit. You said that the former is undergoing voluntary therapy through Appalachia.
Yes, Your Honor. Yes, and that has been e-filed with the clerk of court. I believe Miss Jasmine Queen e-filed a status report on 8/5/2021.
Looking at it now. So, Mr. Barden, this is definitely a step in the right direction. However, this time I'm not going to grant the peaceful contact with Ms. Kennard. I will allow you to communicate through talking to parents if you have issues that arise related to child care or visitation. You can use talking to parents to communicate with each other if need be. Through that, I will allow the GPS monitor to be removed from your leg. Any costs that have already accrued as it relates to the GPS monitor, like a civil judgment for those, you certainly can consent to give your consent, and that will resolve that issue. But until the case is resolved, for now, I want you to continue with your therapy. It's something that's beneficial to you, but talking to parents is how you'll need to be in touch with each other, right?
Yes, Your Honor, and I'll explain that to Mr. Barden as soon as we get off. Thank you.
The Barden hearing is concluded. I believe we had one more with Shane Rothman.
Yes, Your Honor.
Ms. James was the attorney for this one.
Yes, Your Honor.
I will call her, Judge, just 1 second.
And Mr. Loftman, we were scheduled to address your case this morning, but we're going to do that this afternoon. And I will let you know that the judge did grant and the state did agree to a reduction of 10 grand already, but we're going to go ahead and get your testimony on record and go through the whole hearing, okay?
Yes, ma'am. We'll just wait for Ms. James to join and then we'll get started.
Yes, Your Honor.
Microwave? What are you talking about, Mr. Zulu? I'm back in the office. I'm about to get ready for tennis. And what happened? So did they add one more hearing? Or is it over? Let me know in the chat. Is this over? I was getting my tennis clothes. Is this still happening or is it done? I missed the last couple of minutes. All right, I'll leave it on for a little bit. Let's see what happens. Mic is on. It's supposed to be on. This is Mentor Lawyer. Hello. There's no need for a WTF on my chat. It is a Zoom hearing that I'm recording with the court's permission because the court doesn't allow direct transmission of the Zoom. I have to film it with a camera.
Right, good to go?
Yes, I just don't see Mr. Loftman now.
Get one, lose another.
I think we've done pretty well today considering everything.
It's like one of the board games I play with packs. Bingham, Bingham, lose the Loftman. All right, if you can ready on the job, please put Mr. Loftman back in the seat.
Yes, sir. Hey, Walton, what happened here? Seat. He was sitting in the seat, and he is no longer there. He's back in the seat there, about to start again.
maybe we can move this along. What is the number of room sought, Ms. Fernandez?
Yes, Judge. Essentially, right now, with the current reduction in bond, he still needs, including the help of the bondsman, who would still have to pay $1,450. His bond is set at $14,500 right now. Mr. Loftman is able, with help of friends and family, to essentially round up about $1,000. And there he is.
There it is.
Mr. Loftman, can you hear us?
Yes, ma'am.
Okay. So Judge, essentially what we're asking for is a reduction in bonds so that he's able to use, with the help of friends and family, about $1,000 to bond out. Right now, our stance is, and I'll rely heavily on my motion, that the monetary bond that even set at even the amount that was reduced to today is still essentially unaffordable and rises to pretrial detention, which I don't believe that the state has put on sufficient or any evidence to go ahead and have him held as pretrial detention. So if Your Honor, if I could, I'd like to take some testimony from Mr. Loftman.
Mr. Laughlin, please raise your right hand, sir. Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, sir.
You will over him. You may inquire when you're ready.
Thank you, Judge. And I'll just note for the record that Mr. Loftman is currently at Leon County Jail, so he is being held in custody. Mr. Loftman, where do you have a job, or where do you work usually when you're not in jail?
With Gaskins Coatings Company. It's Gaskins Coatings Company with Keith Gaskins.
Okay. And how often do you get paid at that job?
Every week.
Every week? And how long has it been since you've been able to work?
I haven't worked in over a year, but I haven't spoken with my boss, and he said that he would put me back on the payroll.
Okay, so you, just for clarification, you're saying that if you were able to get out, you would have a job, right?
Yes, ma'am. Yes, ma'am.
For about a year now, you have not been able to work.
No, ma'am. I just haven't been working.
Okay. Have you been receiving any kind of federal funds or unemployment funds?
No, ma'am. I haven't received anything.
Do you have any savings?
No, ma'am.
Okay. Do you own any property?
No, ma'am.
Do you have any debt?
To the IRS. Yes.
And do you know about how much that is?
Maybe about $1,000.
Do you have family and friends or someone who would be able to help you bond out?
I believe I have, maybe my mother would help me to bond out, but she works at North Florida Cosmetology College, and I don't know how much money she really has, but I'm hoping, a smaller amount would maybe, someone would come to relieve me.
And I've represented to the court that maybe around $1,000 bond would be something that your friends and family can come up with. But I want to make sure I'm clear, because that's something that you told me before you were able to call them and get that information. So what is the highest amount of bond that you think that your friends and family can help you to bond out?
I want to say close to 1,000. I mean, 1,000 would be much more suitable in my scenario. Just because with the COVID out there, and not a lot of people have been working in stimulus checks and stuff. So maybe people come to corral to help me. I mean, seeing
Where?
COVID and everything. So.
Right. Where do you live?
I'll be living with my mother. And
Do you have a safe place to stay if you're granted release, if you're able to get out?
Absolutely. In a nice neighborhood in Cologne, and my mom will be taking me in. So
where did you live prior to being incarcerated?
I was living in Woodville, Florida, and it was, it's not the right. It's about, I'm trying to go to rehab and stuff, so that ain't,
Where were you born?
I was born in Hollywood, Florida.
Okay, and where have you lived in the past 5 to 10 years?
I've lived here in Tallahassee all my life, really.
And where is the majority of your family live?
Here in Tallahassee.
Do you have a way to safely get to court? If you were able to bond out, would you be able to make it to court either by Zoom or in person?
Absolutely, absolutely. My mother would give me, provide transportation or any means of help to seeking, drug rehabilitations or drug screening or pretrial releasing, any sort of R&R, if that's available. I mean, just my mom's there to help me as long as I'm being screened for drugs.
That's wonderful, thank you.
Okay.
And that's all the questions I have for you.
Okay.
Do you have any examination related to the harm?
No, Your Honor.
Right, what is the defendant's criminal history?
So, Judge, I'm not sure if this makes the issue moot, but Mr. Loffman does currently have 2 outstanding order to show causes from McCullough. Both of those are with a no bond hold. I'm guessing it's because he picked up these charges. Those case numbers, I can give them to you, Your Honor, are 20404 CF and 20403 CF. And both of those cases, the charges are sale of controlled substance in both instances. So Judge Fleury has signed a no bond hold KPS for both of those cases out of McCullough County. That was dated in June, and I do not see any updates since then.
Yes, we were not aware of the situation, Mr. Mendoza.
No, Your Honor, we were not. Mr. Loffman wasn't either because we talked about his release. He clearly didn't know there was a KBS. I didn't either, Your Honor. And this case was just recently transferred to me. So, Your Honor, I would still ask to move forward with the bond reduction in the event that we're able to go ahead and resolve one or the other. I would still want to go ahead and have him have the ability to bond out if necessary. These no bond cases were clearly done before he was here as a result of this case. So I don't think that those should have any consequence on this case here. I would ask for him to be served with them right now and make sure that he's getting credit on those, but I would still like to move forward with the bond reduction for here.
All right, and this was just ammunition, these were not weapons that he was alleged to be found with.
Yes, Your Honor, not weapons, but ammunition.
All right, as to counts 3, which is the possession of ammunition, the possession of paraphernalia, and the maintaining of a nuisance structure. As to those counts 3, 4, and 6, I'll put the defendant on pre-trial. All other conditions that were announced at first appearance concerning no weapons, no drugs, random testing, things of that nature, all those will carry forward. Bonds, which have already been reduced, counts 1 and 5, those will remain the same. Count 2 will remain the same. Mr. Loffman, I don't know if you're going to plan to bond out in light of the fact that you have these holds or not, but ultimately you have some matters in front of Judge Fleury that he wants to see you for as well. So you have that knowledge. Anything else before we conclude?
Yes, Judge, but Your Honor, I sent a proposed order through the portal and to Ms. Underwood via email for the hearing this morning. Would Your Honor like a new one or just to adopt that one and edit it?
I believe I've already signed the one as a
Okay.
reduction. If you can just send another one through the portal.
Will do.
That'll reflect the pretrial counts. That should clear it up. And from there, Mr. Rothman, it's your decision if you wish to bond out or not. But again, you have some holds out of McCullough.
And Judge, is it possible to have him served with those?
I can, if you can tell the jail staff to please serve him with any outstanding warrants. Right, it's 12,500, I believe, is what he has now, instead of 20,000 or 19,000.
Maybe, you said pre-trial 35, 3, 4, and 6, right?
Let me go back into it.
3, 4, and 6, because that would only given $12,000.
The paraphernalia count, the drug house count, and the possession of ammo by convicted felon count. So that's 3, 4, and 6 pre-trial for those.
The rest stay the same.
Rest stay the same. I'm not sure if Ricola is holding on to it or what, but, deputy with me in the courtroom is saying he's not seeing it.
I don't see a whole lot. I don't see it's probably in their system down there, and that's why Ms. Bingham did see it, but there has not been a whole face for me on it because he hasn't been served with their warrants, yeah.
So this Bingham has the federal secret probation access to.
I mean, I'm just looking at CCIS.
Mr. Loughlin, just so you understand what's going on, your bond has been reduced, and I can give you a call and talk to you about the amount. But essentially, the second if you're not served with them at the jail and you actually do bond out and step outside, at any point anybody can serve you with those warrants, and so you would be back in jail and you would have used that money for that instead of needing something else that you might have needed. So right now you have those holds, and I'm just trying to make sure you get credit for the time that you're doing in there for those in McCullough as well. So it might be best, it's up to you, but right now I don't know that if you get out, it might be for a day or so.
That's fine. Yeah, so what you're saying is if I do make bond, if I post bond, I'll be placed on pretrial in Leon County, but then they may come and get me with a KPS warrant in Wakala.
Yes, the moment you go to pretrial to check in, they'll serve you with the warrant, and then you'll be held no bond on those charges, either here or in McCullough, wherever you're picked up.
Okay. So what if I turn myself in Wakala? Will that work that way? You don't know?
That's fine. I don't see any reason that wouldn't work. We're not able to serve you with those warrants in the jail right now. So you can call your mom right now, and if you want to be bonded out, then you can go and you can turn yourself in over there in McCullough.
Okay. Your Honor, did I post bond for the marijuana charge, or is that still held against me?
Nothing being held against you, it's just the charge that you have right now until it's resolved.
Yes, sir. Okay. So then, therefore, 1,200 is how much I need.
12,500 to 1250.
About 1,250. Okay.
Yeah, and we can talk more about that. I can give you a call.
Now, I don't know. Has anyone discussed with the drug treatment?
This is not, Mr. Loughlin, this is not the moment for that. We'll talk more about that.
Okay. Yes, ma'am.
5 minutes or any recess.
Thank you.
Okay, thank you, Judge.